October 18, 2017, a quiet street in suburban Atlanta. A six-member FBI SWAT team breaches a front door before dawn. A flashbang grenade goes off inside the house. Hilliard Toy Cleat is pulled from a closet. His partner, Katrina Martin, is there, so is her 7-year-old son. And it is the wrong house. The team meant to hit a suspected gang hideout at 3741 Landau Lane. They were standing in 3756 Denville Trace. As the Supreme Court later laid it out, the cause was an agent's reliance on a personal GPS device, combined with the team's failure to notice the street sign and the house number visible on the mailbox. So, the family sued, and that is where this stops being a story about a raid and becomes a story about a question almost nobody can answer. Who exactly do you sue when the person who wrecked your house works for the federal government? Most people assume there is one answer. There are two, and which one you get depends entirely on who wronged you. If a city police officer violates your rights, you sue under a law called Section 1983. We have covered that one. It is a real statute passed by Congress. But Section 1983 only reaches people acting under state law. A federal agent is not acting under state law, so that statute does not reach the FBI, the DEA, or the ATF at all. For most of American history, that meant there was no lawsuit. Congress had simply never written one. Then, in 1965, 6 federal narcotics agents walked into Webster Bivens' Brooklyn apartment. No search warrant, no arrest warrant. They searched the apartment, in the court's words, from stem to stern. They manacled Webster Bivens in front of his wife and children and threatened to arrest the entire family. He was taken to the federal courthouse in Brooklyn, interrogated, booked, and strip-searched. The narcotics charge against him was later dismissed. He said it caused him great humiliation, embarrassment, and mental suffering, and he asked for $15,000 from each agent. Bivens sued the agents personally. Every court told him the same thing. There is no law that lets you do this. The trial court threw the case out on 2 separate grounds. 1, that no federal lawsuit like this existed. 2, that the agents were immune anyway because of the office they held. The appeals court affirmed on the first ground and never reached the second. In 1971, the Supreme Court disagreed. 6-3, it held that he could sue the agents for money damages directly under the Fourth Amendment itself, with no statute at all. The court had, in effect, created the lawsuit. That is unusual, and it matters for everything that comes after. Because a remedy the court invented is a remedy the court can decline to extend, and for the last 45 years, that is exactly what it has done. The court extended Bivens twice more, in 1979 and 1980, a workplace discrimination claim, a prison medical care claim. That is the whole list. Since then, in the court's own words in 2025, after 1980, we have declined more than 10 times to extend Bivens to cover other constitutional violations. In 2017, the court built the test that does the work. Is this a new context? And if it is, are there reasons to let Congress handle it instead? In 2022, a bed and breakfast owner in Blaine, Washington named Robert Boole sued a Border Patrol agent who he said threw him against an SUV and then to the ground, an excessive force claim against a line federal officer on American soil. 6-3, the Supreme Court said Bivens does not reach it. Boole had also claimed the agent retaliated against him afterward for complaining. The court said Bivens does not reach that either. Both claims closed. And in 2025, the court applied the same answer to a prisoner's excessive force claim. The court's reason is not hidden, and it is worth stating in its own words. In all but the most unusual circumstances, prescribing a cause of action is a job for Congress, not the courts. Supporters of that view say it is basic separation of powers and that the alternative is worse. If judges can invent a lawsuit, judges can invent its limits too, and nobody ever voted for either one. Congress can write this law whenever it wants to. Critics answer that Congress has not written it in 50 years, and that a right you cannot enforce against anyone starts to look less like a right and more like a suggestion. You do not have to pick a side to see the practical result. Suing the individual agent personally almost never works now. There is also a second separate shield, and people mix these two up constantly. Qualified immunity. That is the doctrine that protects an individual officer unless the right he violated was clearly established. Bivens asks whether the lawsuit exists at all. Qualified immunity asks whether this particular officer is protected from it. They are different questions, and a claim can die on either one. So, if you basically cannot sue the agent, what is left? You sue the United States of America. And to understand why that is even a question, you need one old idea. For centuries, the rule was that you cannot sue the government at all unless the government agrees to let you. Lawyers call it sovereign immunity. It is a strange rule when you say it out loud. The party that wrote the laws also decides whether it can be taken to court over them. In 1946, Congress agreed to let some of it happen. The law is called the Federal Tort Claims Act. Under it, the government gives up part of that immunity and accepts being sued for certain wrongs its employees commit. For a long time, it did not cover this. The act specifically excluded claims for assault, battery, false arrest, and several others. Exactly the things that happen in a bad raid. Then came 1973 and a town called Collinsville, Illinois. Federal agents hit the wrong house. 15 state and federal officers ransacked the home of a man named Herbert Giglotto, tied him and his wife up at gunpoint, and threatened to shoot him if he moved before realizing, in their own words, that they had the wrong people. They then moved on to the home of Donald Askew and terrorized another innocent couple before admitting they had acted on a bad tip. Congress responded in 1974 by writing an exception to the exception. It is called the Law Enforcement Proviso. If the person who wronged you is a federal investigative or law enforcement officer, someone empowered to execute searches, seize evidence, or make arrests, then 6 claims come back on the table: assault, battery, false imprisonment, false arrest, abuse of process, malicious prosecution. That provision, written because agents raided the wrong house in 1973, is the exact provision the Supreme Court was arguing about in 2025, because agents raided the wrong house in 2017. Now the part that costs ordinary people their cases, and it is not dramatic at all. It is a form and a clock. You cannot walk into federal court first. You have to present your claim in writing to the agency itself. The statute says a claim is forever barred unless you do that within 2 years. 2 years, not from when you find a lawyer, from when the claim accrues, which courts measure from the point you knew, or should have known, that you were hurt and what caused it. After that, if the agency formally denies it, you have 6 months to sue. If the agency simply sits on it for 6 months, you may treat that silence as a denial and go to court. And there is one more trap, which a man named James King found the hard way. King was stopped by members of a federal task force in a case of mistaken identity, and the encounter turned violent. He did what a lawyer would tell you to do. He sued the government under the Tort Claims Act, and he sued the officers personally. His claim against the government was thrown out. In 2021, a unanimous Supreme Court held that even that kind of dismissal can count as a judgment on the substance of the claim. And that matters because of something called the judgment bar. Once there is a judgment in your Tort Claims Act case, you generally cannot bring a second action against the employee over the same events. But here is the part that usually gets left out. The Supreme Court did not decide whether that bar applies when both claims are filed in the same lawsuit, the way King filed his. It sent that question back down. A divided federal appeals court later answered yes. The Supreme Court declined to take the question up again. More than a decade after the encounter, King had still recovered nothing. 2 shots at accountability, and one of them can shoot the other. Which brings us back to the family in Atlanta, and to the defense that nearly ended their case before the Supreme Court ever saw it. The government argued the raid involved the kind of judgment call the Act does not let a court second guess. Lawyers call it the discretionary function exception. The idea is that some government decisions are policy choices, and a jury should not be grading them after the fact. Deciding how to plan an operation can count. Deciding to hit the wrong house, the family argued, is not a policy choice at all. The trial court sided with the government. So did the federal appeals court. By the time the case reached Washington, the family had lost twice. On June 12, 2025, the Supreme Court ruled 9-0, Justice Gorsuch writing. And here is what it did. Precisely, because this part gets reported wrong. It did not award them anything. It did not decide they win. It decided two things. The first, it settled outright. The court below had accepted an argument that federal agents carrying out federal policy are shielded from these suits because federal law overrides state law. The Supreme Court rejected that. The Tort Claims Act, it said, gives no such defense. The second question, it did not settle. It held that the court below used the wrong analysis, threw out that decision, and sent the case back to be done again. Their case is alive. It is not over. They can still lose. And there is one more thing worth knowing about that road, because it cuts both ways. When you sue the United States, you are suing the government, so if you win, the government pays. The money does not come out of the individual agent's pocket. Supporters say that is the point. It compensates the person who was hurt without making officers personally afraid to do a dangerous job. Critics say a system where the person who broke down the wrong door never personally answers for it is not really accountability. So, the plain English version. If a federal agent wrecks your house, suing that agent personally is close to a dead end, and has been for decades. Suing the United States is the road that is actually open. It runs through a form, an agency, and a 2-year clock. For something like a raid, that clock generally starts the day it happens. Courts measure it from when you knew, or reasonably should have known, that you were hurt and what caused it. This is not legal advice, and if this ever happens to you, the deadline is the first thing to ask a lawyer about. But now you know which question to ask.